Welcome to Employment Law This Week. I'm George Whipple. Our top story, Washington State bans the box. With the governor's signature, Washington becomes the 11th state to extend background check reform to private employers. The state's Fair Chance Act prohibits employers from obtaining criminal background check information until after the applicant has met basic qualifications for a job. It also prevents employers from automatically excluding applicants with a criminal record. 31 states and more than 150 cities and counties nationwide have now adopted similar ban-the-box legislation for public or private employers. Katrina Walasik has more.
Ban-the-box legislation does not completely ban all background checks for employers. In Washington state, for example, employers are not permitted to ask about an applicant's criminal background history during the initial application process. However, once an employer determines that an employee is otherwise qualified for a position, then they may inquire as to that individual's criminal background history. Additionally, ban-the-box legislation does have many exceptions, and in Washington state, employers who are in the business of requiring unsupervised access to children or at-risk adults, employers working in the financial services industry, and employers engaged in law enforcement or criminal justice agencies are always permitted to conduct criminal background checks during the initial stages of the application process.
A new lower standard for punitive damages under New York City's human rights law. The Court of Appeals for the Second Circuit held that the legal standard for awarding punitive damages under the city human rights law is more liberal than the federal standard under Title VII. The court applied a ruling from New York State's highest court on a certified question. The district court in this case had instructed the jury to apply the federal standard. The circuit court remanded the case for a determination based on a new standard under the New York City law. The NLRB has once again extended the deadline for comments on the so-called ambush election rule adopted in 2014. Employers now have until April 28th to submit feedback. The board is seeking data and comments and may consider whether the amended rule should be modified, rescinded, or left as is. The board first announced that it would solicit public comments in December, when Republicans made up the board majority. Earlier this month, a Senate committee approved President Trump's nomination of management lawyer John Ring to the board. His confirmation by the full Senate would return the NLRB to a 3-2 Republican majority. Sexual harassment allegations appear to have brought down the Weinstein Company. In February, New York Attorney General Eric Schneiderman filed a civil rights lawsuit against Harvey Weinstein and his company. This came amid similar lawsuits that accused the company of aiding and abetting Weinstein's behavior. The lawsuits and related accusations caused a group of investors who were interested in buying the company to pull out. On March 19th, the company filed for bankruptcy protection and released anyone who suffered or witnessed any form of sexual misconduct by Harvey Weinstein from non-disclosure agreements. Now it's time for our tip of the week. Diane DiResta, owner of DiResta Communications, is here with some tips for getting to the point in communications.
When you get to the point, you increase your credibility and your clarity. When you have more credibility, when you sound like you know what you're talking about, people trust you. And when your message is clear, it gets through. So how do you get to the point? Well, the first thing is to be prepared. Don't wing it. Secondly, have the end in mind. Start with your goal or your purpose, because when you know your purpose and you veer off, you'll be reminded of why you're there and you'll be able to get back to the point. Another thing to keep in mind is that too many times people get mired in the details. So start at a high level, at the 30,000-foot view. Headlines first, details follow. So don't get involved in a story, because remember, it's not everything you know, it's tell them what they need to know.
Thanks, Diane. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.